Evelyn, you're live.
Hello, everyone. Thank you for joining me on our Wednesday LinkedIn Live with Evelyn Ackah. I'm the founder of Ackah Business Immigration Law. And today I want to talk to you about LMIAs and work permits because employers and foreign workers are still making decisions based on one very risky assumption that a job offer means the person can start working. It does not. A job offer is not a work permit. A submitted LMIA, Labor Market Impact Assessment, is not a work permit either. Even a positive LMIA is not permission to begin working in Canada yet. These are separate steps handled by different government departments, and each step has its own requirements. When employers rush the process, promise a start date too early to an employee, or use the wrong LMIA stream, the consequences can include delays, refusals, unauthorized work, and compliance penalties. So my message today is very simple. Do not treat this as paperwork to complete after the hiring decision has already been made. The immigration strategy needs to be reviewed before any commitments are made to that employee. This discussion is for general information only and is not legal advice. Every employer, position, and worker has different circumstances, and I'm going to explain to you what an LMIA actually does, when one may be required, and what employers must prove, what workers need before they can even begin working, and what they have to do in terms of applications that are done wrong. So let's get started. An LMIA and a work permit are not the same thing. LMIA again stands for Labor Market Impact Assessment. In most cases, it is the Canadian employer, not the foreign worker, who applies to Employment, Social and Development Canada through Service Canada. Service Canada is assessing the employer, the position, the prevailing wage, and the potential impact of hiring a temporary foreign worker. The employer generally needs to show that the business is legitimate, the job offer is genuine, and the wage and working conditions are meeting the required standards, and that all the recruitment was done to the best efforts to meet their criteria. A positive LMIA means Service Canada has approved that employer's request for that particular temporary foreign worker based on position, wage, location, and all the employment conditions. It does not give the worker permission to start working yet. The worker must still apply to Immigration, Refugees, Citizenship Canada for a work permit. IRCC will assess the worker's qualifications, admissibility, and eligibility separately. So a positive LMIA supports that application, but it does not guarantee approval of the work permit. Employers need to hear this clearly. Do not put someone on the schedule, have them perform productive training in quotes, or allow them to start work because the LMIA was approved. The worker must still get legal authorization that covers the work permit that they're actually able to do. They must have the work permit before they can start working. Not every work permit requires an LMIA, however. The Temporary Foreign Worker Program generally uses LMIA process. The International Mobility Program includes specific LMIA exempt categories, such as certain workers under international treaties like NAFTA or intercompany transferees, some francophone workers outside Quebec, and other defined exemptions. Some people may also hold a valid open work permit that allows them to work for most eligible employers without needing an LMIA. The important point is that employers should not guess. Because advertising, paying the government fee, or promising a start date, before you do all of that, confirm which route actually applies in your situation. An LMIA application that was never required can waste months and thousands of dollars, assuming there was an exemption you could have used. When an LMIA is required, the offered wage, the wage range, helps determine whether the application belongs in the high wage or the low wage stream. And the job title does not decide the stream. The employer has to compare the offered hourly wage with the current threshold for the province or territory where that employee will be working. There are new thresholds that took effect on July 17, 2026, and now for Alberta, for instance, the hourly threshold is $37.50. In British Columbia, it is above it is 38.40, and in Ontario it is 36.92. So you need to know if your position is lower than those rates, that means your position is low wage. But if it's higher, then it's a high wage LMIA. Employers should not increase the salary by just a few cents in order to qualify for high wage, because we're getting more and more questions by Service Canada as to why they're paying somebody maybe significantly higher than the position. The stream changes the employer's obligations. High wage applications generally require a transition plan. Low wage applications face additional restrictions, including workforce caps, refusal to process rules, and in many cases, shorter employment durations. That is why the wage should be reviewed before recruitment even begins, not changed at the last minute because the wrong stream was selected initially. An LMIA is not a form that simply says we found the person we want to hire. The employer must prove that the business and the position meet the program requirements. The application needs consistent evidence showing the following: the business is legitimate and actively engaged in business and operating. There is a genuine need for the position, and the employer can pay the wage for that employee. The job duties match the correct national occupation classification. The recruitment and advertising meet the stream requirements, and the employer properly considered Canadian and permanent resident applicants before hiring the foreign worker. The job title, wages, duties, location, and business must meet all credible stories and must be accurate. Copying an old job description, choosing a more convenient knock code, or creating qualifications around one preferred candidate can undermine the application significantly. Service Canada is not only deciding whether the foreign worker is qualified, it is deciding whether the employer has justified adequately using the program for the specific position. This is especially important for low-wage positions. Under the current refusal to process policy, many low-wage LMI applications will not be processed when the work location is in a census metropolitan area with an unemployment rate of 6% or higher, unless an exemption applies that you can fit into. For the period from July 10th to October 2026, major centers, including Calgary, Edmonton, Toronto, and Vancouver, are at or above the threshold of 6%, which means they cannot do low-wage LMIAs. An employer may have a genuine vacancy, a willing worker, and a complete application, but Service Canada may still refuse to process it because of the wage level, location, and current unemployment rate for Canadians. Certain occupations and sectors may be exempt, but employers must confirm that the position actually qualifies. Do not submit first and investigate later. Review the work location, the wage stream, the unemployment rate table, the workforce cap, and any available exemption before paying the fee to immigration or to ESDC and beginning recruitment. This one review can prevent weeks of work from being spent on an application that was never eligible to move forward because it was under the low wage category. After a positive LMIA is issued, if you're lucky, the worker normally uses the LMIA documents to apply for an employer-specific work permit. IRCC may still review whether the worker has the experience, education, licensing, or other qualifications required for the role. And the officer may also assess medical, criminal, or immigration admissibility and whether the application is credible. Workers should make sure the job in the work permit application matches the LMIA approved work permit. Employers should make sure the offer has not changed at all while the application is being processed. Most importantly, the worker should not start until the proper authorization is in place. My employer said it was fine is not a defense to unauthorized work. An employer cannot override Canadian immigration law. They must not start until they fully qualify and have a new work permit. Employers sometimes think the immigration work is finished once the employee starts work. It is not. The employer must continue providing the approved job wage and working conditions and must keep the required records for 6 years, beginning on the first day of the authorized employment period. Service Canada can inspect employers' workplaces, and inspectors may review payroll, hours, duties, work locations, recruitment records, and whether the commitments made in the LMIA application were actually followed. This is where ordinary business decisions can create immigration risk. A manager changes the employee's duties, payroll reduces the hours, the work is moved to another location or business unit. The company lowers the wage or restructures the role. Those changes may seem operationally reasonable, but they may no longer match what Service Canada and IRCC has approved. Before making a material change, you must review the immigration consequences with a lawyer. Do not wait for an inspection letter to find out that you are offside and could be barred from using the program. Noncompliance can lead to warnings, financial penalties, suspension or revocation of LMIAs, publication of the employer's name, and bans from hiring foreign workers ever again. This needs to be understood by HR, payroll, managers, and leadership, not only by the one person who filled in the LMIA application. The organization must be fully aware. The most common problems are usually preventable. Promising a start date before confirming the immigration route and timing. Assuming a positive LMIA guarantees the work permit. Using the wrong wage stream or an outdated threshold. Submitting a low-wage application without checking the refusal to process rules, and using duties or not code that do not match the real job. Allowing work or productive training before authorization is in place, and changing wages, hours, duties, or location of work without reviewing compliance with Service Canada. These issues are much easier and less expensive to prevent than to repair after a refusal or unauthorized work or a non-compliance finding that gets you into real trouble. So, LMIAs and work permits are connected, but they are not interchangeable and they are not the same thing. The LMIA is primarily the employer's labor market application. The work permit is the worker's legal authorization to work in Canada. Employers need to confirm the right program, the right stream, the right wage, the recruitment plan, and the refusal to process rules before they make any commitments to employees, potential employees. Workers need to confirm that their authorization has been approved and that it matches the employer, occupation, location, and work that they will actually perform. Do not ask only, can we get an LMIA? Ask whether an LMIA is required, whether the application is eligible to be processed, and whether the employer can meet the ongoing obligations and whether the worker can qualify for the work permit. That is the full strategy here, and it needs to be considered before the worker starts, not after a problem occurs. Thank you for joining me today. I'm Evelyn Ackah, founder of Ackah Business Immigration Law. If your company is planning to hire international talent, or you have received a Canadian job offer and you are uncertain about the correct work authorization, please get advice before you make any commitments, pay any fees, or begin working. I look forward to answering your questions. We've got a question right now. The question is, does a Canadian job offer mean I can start working? And the answer is no. A job offer by itself is not authorization to work in Canada. The employer may need a positive LMIA, or the position may be LMIA exempt, and you must get that offer. And then the worker must have the correct work permit or valid exemption before starting. Who applies for the LMIA? We get this question a lot. You need to know it is the Canadian employer that applies. It is an employer application, not an application for the foreign worker. If the LMIA is approved, the employer provides the decision documents to the worker, who then applies to IRCC for the work permit. Does every employer-specific work permit require an LMIA? No. Some employer-specific work permits are LMIA exempt under treaties like NAFTA or General Agreement of Trade and Services. The employer and the worker still need to identify the correct exemption and follow the required process to get a work permit. How do you know if your position is high wage or low wage? You have to compare the offered hourly wage with the current threshold for the province or territory where the employee will work. And the thresholds can change every 2 or 3 months, so employers should verify the amount at the time of filing. Can the employer raise the wage just to use the high wage stream? The wage must still meet the prevailing wage rules and be credible for the occupation, location, and employer. Artificially adjusting the wage to avoid the low wage requirements can weaken the application and may lead to a refusal. Why would Service Canada refuse to process a low wage LMIA? Many low wage applications are not processed when the work permit location is in a census metropolitan area, unless the unemployment rate is lower than 6%. If it's higher than 6%, then there is the refusal to process, unfortunately, and you can't get a low wage LMIA. This is what we're experiencing right now for many of our clients that are under the low wage. They cannot get an LMIA because of where they're located and because of the unemployment rate currently. Can a worker change employers on an LMIA-based work permit? Not automatically. The new employer may need to complete a new LMIA or an LMIA exempt process, and the worker may need a new work permit or specific authorization before starting the new job. And can an employer change the worker's duties or location? Material changes lead to create some compliance problems. So if they no longer match what the LMIA approved, you may need to go back to Service Canada and get permission from them in order to change some material aspect of the job. Does an LMIA guarantee permanent residence or express entry points? No. Unfortunately, at the moment, an LMIA does not guarantee permanent residence. Express entry no longer gives you what formerly was 50 or 200 points toward your CRS score. Now it does not help you at all with permanent residence, unfortunately. What records should an employer keep? Employers should retain the LMIA application, all the recruitment evidence, all the applications received by people who applied for the job, payroll records, hours, and duties showing all the conditions were followed, and keep them all for at least 6 years in case you get audited by Service Canada. I hope today's LinkedIn Live talking about LMIA has been useful. If you have any questions at all and you want to talk through your options, if you're an employer and you want to hire a skilled worker and you want to use the temporary foreign worker program, please give us a call. It is very complicated and it's very unlikely that most employers can do this on their own. You need professional expert advice and support. Look forward to speaking with you next week. Thanks so much. Bye-bye.